Wolf Theiss Soundshot. Insights and analysis from one of the leading law firms in Central, Eastern, and Southeastern Europe.
Hello and welcome to the Wolf Theiss Soundshot Podcast, Digital Law Edition. My name is Philip Wrabetz.
I'm Jakub Pietrasik.
And together we are happy to present to you the latest episode of our new podcast series about the rapidly changing world of digital law. In today's episode, Jakub and I will be talking about the EU Artificial Intelligence Act, the world's first comprehensive regulatory framework for AI technologies. In light of the rapid advancement of artificial intelligence that we are all witnessing at the moment, this groundbreaking law is set to have a profound impact on businesses, individuals, and our digital economy as a whole. We're thus excited to have you on board for this episode as we explore the new requirements and far-reaching implications of the Artificial Intelligence Act. So Jakub, what is the AI Act all about?
Philip, let's start with a brief introduction of what AI Act really is. So generally, the AI Act is the first piece of legislation globally which comprehensively regulates all the issues connected with the legal framework of artificial intelligence. It applies to AI systems that are defined as machine-based systems, which generally are autonomous, show a certain level of adaptiveness after deployment, and based on the input they receive, which can generate outputs such as predictions, recommendations, or decisions that can influence physical or virtual environments. The AI Act divides the AI systems into four main categories based on the risk level they present. So we have prohibited AI systems with an unacceptable risk level. We have high-risk AI systems, as well as we have medium and low-risk systems. As part of the definition of AI system, the Act also covers general-purpose AI systems, which have recently received the most publicity around the world, and which include systems of a general nature that can be used in a wide range of downstream systems or applications. ChatGPT is the best example here. It meets the criteria of the AI system as such, plus it can be used for many different purposes, particularly for direct use, as well as for integration with other AI systems, which makes ChatGPT a general-purpose AI system.
So it is fair to say that the AI Act has a quite broad material scope of application, covering a wide range of technologies, from rather trivial predictive software applications to complex autonomous systems. But how about the AI Act's personal scope of application? In other words, who are the main stakeholders affected by the new law?
The AI Act is particularly important to three types of stakeholders. So first of all, AI system providers, which are entities developing AI systems and placing them on the market under their own brand. Example here, all creators of AI systems, all the big players providing AI systems on the market. Second, deployers, so entities using AI systems under their own authority. Example, public authorities implementing AI systems in their public services, or entities having their own product, which is based on the model provided by an external AI system provider. And third category, affected persons and users. So all entities or individuals being subject to AI systems in their real life. At the end of the day, all three types of entities are really interested in how the AI Act regulates specific rights and obligations, starting from the technical design of the AI system, going through all the regulatory requirements relating to an AI system as such, finishing on potential liability issues and claims, as well as financial penalties for non-compliance. It's crucial to note here that the AI Act is important not only to big tech and global players. It will apply to every single company or entity involved in creating or using an AI system. From a practical angle, for all companies and also our clients, it's important to assess whether they are captured by the AI Act and whether their product falls under the category of AI system. We'll try to explain how to complete such assessment further in this podcast. But Philip, bring us to speed on current formal procedural status of the Act, please.
Sure, Jakub. As our listeners may have heard, after almost 3 years of negotiations, the EU institutions were finally able to reach a political agreement on the AI Act in December 2023. This historic agreement put the final text of the AI Act on its path, which text was subsequently confirmed by an overwhelming majority in the European Parliament on March 13, 2024. 523 votes in favor, only 46 against, with 49 abstentions. So quite a strong statement in favor of the new law and in favor of the need for AI regulation in general. What is left now are lawyer linguistic checks and the formal endorsement by the Council. The AI Act will then enter into force 20 days after its official publication and become fully applicable within 24 months, so likely in late 2026. In this regard, however, some exceptions apply. Most importantly, the ban on AI systems with unacceptable risk will already become applicable within 6 months, so possibly still in 2024. Moreover, the rules regarding general purpose AI become applicable already within 12 months, so likely in mid-2025. And lastly, the AI Act will apply within 36 months for AI systems that are a product or are intended to be used as a safety component of a product, which is already required to undergo third-party conformity assessment under EU product regulations.
This is pretty fast, isn't it? Given the scope and complexity of the regulation, it's really recommended to start preparing for the new rules.
Exactly, I totally agree. And this, of course, begs the question how companies and organizations should prepare for the new framework. What are the real implications of the AI Act?
In order to understand the implications of the AI Act, we need an example based on which we'll be able to present how the AI Act will be applied in practice. We also believe that an example from the HR, human resources sector, can be pretty nice here, as it generally can be applied in all types of businesses. So let's imagine a tool for scanning, analyzing, or sorting CVs with a functionality to make its own recommendations or even decisions relating to job candidates. Let's call it a CV analysis tool, and this could be our example for today's podcast. In the first step, we need to answer a question. Can such a CV analysis tool be qualified as AI system? To answer this question, we need to check if such tool falls under the definition from the Act. So if such tool is machine-based, so computer-based, plus if it's trained on some data, plus if it has certain level of autonomy and learns and is able to generate outputs or decisions affecting real individuals, then probably it can be qualified as AI system under the AI Act. In practice, if the CV analysis tool would be able to make its own decisions or recommendations regarding specific job applicants, and for example, if it had a functionality of choosing CVs that qualify for the next phase of recruitment process, as well as selecting CVs that are dismissed, then such tool would potentially fall under the definition.
Okay, so assuming we are actually dealing with the technology here that is covered by the AI Act, what would be the next step of the legal assessment?
The second step, we need to assess whether such CV analysis tool would be qualified as a prohibited AI system, high-risk AI system, or limited risk AI system. Starting with the prohibited AI system. Such systems are directly prohibited under the Act. What is important, AI Act lists the categories of such systems and defines which exact systems present unacceptable risk level. Among others, prohibited AI systems or systems that use subliminal techniques or manipulative techniques to impair the person's individual decisions, or biometric categorization systems, or real-time biometric identification systems, or social scoring systems, criminal prediction systems, and many more.
Do you think, Jakub, that this category of prohibited AI systems could reasonably also apply to our CV analysis tool?
Generally, no. The prohibited AI systems are pretty well defined in the Act, and without verifying detailed features of our CV analysis tool, we can assess that the tool shall not fall under the definition of the prohibited system.
Okay, so good news there. Our imaginary tool is not outright prohibited, and we can move forward. I guess the next logical question would be whether our CV analysis tool could qualify as a high-risk AI system under the AI Act.
Generally, also in relation to high-risk AI systems, the Act provides a broad definition, including a sample list of AI systems qualified as high risk. The list is provided in the annex to the Act and involves, inter alia, systems used in employment or employer-employee relations, featuring systems intended to be used for recruitment or selection of natural persons. So in practice, with very high probability, our CV sorting tool with its functionality to promote certain job applications and dismiss others could be qualified as high risk, yes.
Interesting. And once you have made this basic assessment that our imaginary tool, our hypothetical tool could be qualified as high risk, are there still ways to escape the scope of the AI Act? Are there any exemptions available?
Yes, good point, Philip. So generally, according to the Act, the high-risk AI system shall not be considered as high risk if it does not pose a significant risk of harm to the health, safety, or fundamental rights of natural persons. This assessment must be made individually by the system operator on a case-by-case basis. Only if the system does not pose a significant risk, the system provider may avoid being subject to the regulatory requirements from the Act. Consequently, depending on the outcome of the assessment, we could decide whether our CV analysis tool would be captured by the full regulatory requirements or whether it would be exempted. In practice, CV analysis tool from our example would probably be qualified as posing high risk for individuals, as it would affect the prospect of success in the recruitment process involving a given job applicant. In other words, potential damage to the job applicant being subject to such tool might be pretty high.
Understood. But let's assume for a moment that our CV analysis tool is in fact not high risk. What then?
If our CV analysis tool was not qualified as high risk, then it would probably fall under the last category, that is medium or low risk, which this type of systems are not captured by the strict regulatory requirements under the Act. In this area, mere information and transparency requirements and voluntary codes of conduct apply respectively. But all in all, summing up, in order to assess the given tool, app, product, or any other solution, we need to follow the assessment path similar to the one described for the CV analysis tool. Of course, this is only an example and it was really simplified, but generally it shows the methodology that should be applied by all entities developing or deploying AI systems.
Thank you, Jakub, for this very practical way of approaching the scope of the AI Act. Now, let's talk about what the implementation of our CV analysis tool or other high-risk AI systems actually means for the involved players. Certainly, the bulk of compliance obligations under the Act targets the providers of AI systems, which includes in particular developers. Before placing a high-risk AI system on the market, these providers must register their system in an EU database and subject it to a strict conformity assessment, ensuring that the system complies with the comprehensive new requirements under the AI Act. And these requirements are really quite extensive. For example, providers must implement and document sophisticated risk management systems throughout the entire lifecycle of the high-risk AI system. This comprises, among other things, the identification and analysis of the known and reasonably foreseeable risks, as well as the adoption of targeted risk management measures. With respect to our hypothetical CV analysis tool, for example, this would entail the analysis and mitigation of potential risks for the applicant's further career prospects, privacy concerns, as well as the risk of perpetuating historical patterns of employment discrimination. Closely related, providers of high-risk AI systems will also need to implement adequate data governance mechanisms to ensure that the data used for training, validating, and testing AI models are suitable for the intended purpose and of appropriate quality. In the context of our CV analysis tool, this particularly requires measures to ensure that representative data sets are used and that the data sets are not polluted by biases or other undesirable effects. Moreover, to demonstrate compliance with the new requirements, providers must also draw up and maintain detailed technical documentation and equip their systems with record-keeping functionalities for the automatic logging of events during the operation of the AI systems. These documentation and record-keeping obligations, of course, serve to ensure that risks and flaws in the systems can be properly identified, analyzed, and mitigated. For example, this could become necessary if applicants were to raise concerns about potentially discriminatory behavior of our hypothetical CV analysis tool. To avoid any such unwanted outcomes, The EU legislator also emphasized the importance of human-centric AI ecosystems by requiring that humans are always, quote unquote, in the loop. Specifically, the AI Act requires providers to allow human control and interference with an AI system to achieve effective human oversight. Providers must therefore design and develop their AI systems in such a way that they can be effectively overseen by natural persons. On the one hand, providers will thus need to ensure that their systems operate in a sufficiently transparent manner that enables deployers to interpret the system's output and to use it appropriately. And on the other hand, human-machine interface tools will need to be integrated into high-risk AI systems to allow for necessary interventions. So the catalog of obligations is really quite extensive. And finally, it shall also be mentioned that providers of high-risk AI systems will, of course, also need to design their systems to achieve an appropriate level of accuracy, robustness, and cybersecurity.
So, Philip, this example certainly show that an extensive development and compliance effort will be required for providers of high-risk AI systems. But what about mere deployers of third-party AI systems? For example, what about companies that want to use the discussed CV analysis tool for their recruitment? Do they also have obligations under the AI Act?
Certainly, an important point. Deployers too are specifically addressed and subject to quite extensive compliance obligations under the AI Act. In particular, deployers are obligated to closely monitor the use of high-risk AI systems, to keep respective system logs for at least 6 months, and to implement otherwise appropriate technical and organizational measures to ensure that high-risk AI systems are used in accordance with the instructions given by the provider and applicable law. In case issues do arise, for example, biased or discriminatory behavior of our CV analysis tool, deployers may also be required to suspend the use of the AI system immediately and to report the issues to the provider and the competent authorities. Among the manifold requirements for AI deployers, it shall lastly be highlighted that deployers must ultimately also ensure compliance with the AI Act's transparency and human oversight requirements that we talked about earlier. For one, depending on the circumstances, deployers may be required to duly inform affected individuals that they are subject to AI systems and AI-generated decision-making. In addition, it will ultimately also be the deployers of AI systems that will have to actually exercise the human oversight requirements of the AI Act. For this purpose, organizations that implement high-risk AI systems must designate a responsible person that has the necessary competence, training, and authority, as well as the necessary resources and support from its employer. Needless to say, these are only some examples of the new obligations, but they serve to illustrate that not only providers, but also deployers of AI systems will face extensive compliance challenges. Similar to the implementation of the GDPR, this compliance effort will entail, as a first step, a full audit of all instances of development and use of AI within an organization and within the organization's supply chain. Based on this audit and respective risk assessments, organizations will then need to implement adequate technical and organizational compliance measures, such as the appointment of sufficiently AI literate and resourced AI officers and AI governance teams, the conduction of fundamental rights impact assessments, the introduction of internal policies and guidelines, as well as the conduction of employee training measures. And as if all the mentioned challenges were not already enough, on top of all of this, deployers of AI systems will also need to ensure that the new systems and policies are implemented in accordance with existing rules and compliance frameworks, such as GDPR-related compliance systems.
So quite a lot of work to do, both for providers and deployers of high-risk AI systems. But what about general purpose AI systems? Are they subject to similar compliance efforts?
Yes, general purpose AI systems are indeed covered as well. If you remember, Jakub, the Commission's 2021 proposal for the AI Act did not address these technologies at all. However, due to the rapid spread of products like GPT-3 and GPT-4, the regulation of foundation models and general purpose AI became one of the most hotly contested issues in the entire legislative process, with Germany, France, and Italy strongly advocating for mere self-regulation based on codes of conduct instead of mandatory rules. Despite this controversy, the EU institutions ultimately agreed on a special set of binding rules for general purpose AI systems. Unlike high-risk AI systems, they do not need to go through pre-market conformity assessments, and the obligations imposed on them are generally less burdensome than for high-risk systems. However, they are subject to specific requirements in relation to technical documentation, policies to respect copyright law, making available sufficiently detailed summaries of the content of training data sets, and labeling AI-generated or manipulated content in a transparent manner. General purpose AI systems deemed to present systemic risks, on the other hand, are subject to even stricter additional requirements under the AI Act.
Thank you, Philip. Again, this is quite a lot of new and very strict obligations imposed on companies dealing with AI. I think we went through some of the most important points, but obviously there is much more to talk about regarding the highly complex and comprehensive AI Act, and we will definitely keep our listeners and clients up to date. How to conclude this? Generally, the new AI Act is a game changer in tech. The Act will apply to IT businesses, which is obvious, but not only. It will capture also HR business from our example, but also hardware manufacturers, Internet of Things sector, and many, many, many more. It means that we need to remember that AI regulation will apply not only to AI-driven IT systems, but also to the downstream products using AI components or safety parts. In practice, in next few years, almost every technology company will be AI-driven or will more or less rely on the AI solutions. So as we can see, AI Act has also many cross relations with other legislation, for example, GDPR, DSA, Data Act, and many more. At the end of the day, all legal complexities will have to be applied by the tech companies, and we'll do our best to navigate our clients through all these regulatory frameworks.
Exciting times indeed that we are living through at the moment. And one thing is for sure, we will have a lot to talk about in the coming weeks, months, and years with respect to the impact that AI will have on our societies and legal systems. So thanks for listening and stay tuned on what's to come with the Wolf Theiss Soundshot Podcast, Digital Law Edition.
Thank you so much.
Thank you for joining us for today's episode of Wolf Theiss Soundshot. For more information, you can contact us via email at soundshot@wolftheiss.com or visit our website at www.wolftheiss.com.